Welcome to this analysis of judicial drift and the erosion of constitutional adjudication. Today, we are examining a critical turning point in Indian legal history, the Supreme Court's response to the 2026 Special Intensive Revision, or SIR, hearings. Based on the legal scholarship of Gautam Bhatia from February 2026, we will explore how the highest court in the land is navigating, or perhaps failing to navigate, a fundamental challenge to constitutional rights. In the first week of February 2026, West Bengal Chief Minister Mamata Banerjee appeared before the Supreme Court regarding the SIR. The result was a startling contradiction. On February 9, the court issued directions intended to fix procedural hardships. Yet in the same breath, it declared there was no impediment to the SIR being allowed across any state. By providing minor relief for administrative glitches, the court essentially prejudged the core constitutional challenge before the hearing was even over. This brings us to our diagnosis, a shift from adjudicator to administrator. A constitutional court is meant to be an adjudicator, ensuring state organs comply with the Constitution and deciding if a process is legal in the first place. Instead, we are seeing judicial drift. The court has become an administrator, micromanaging how a process like Aadhaar or the SIR is implemented, while completely ignoring the more important question of if it should be happening at all. How does the state bypass the Constitution? Through the mechanism of fait accompli. Look at the timeline. Petitions challenging the SIR were filed as early as July 2025 in Bihar, but by November, the Bihar elections were held using the SIR data. By the time the court held hearings in February 2026, the violation had become an irreversible fact. In these cases, the delay is the decision. Any future judgment becomes moot, because the process is now too big to reverse. This isn't the first time we've seen this normalization of abdication. The SIR case mirrors the Aadhaar trajectory. A challenge is filed 2012 for Aadhaar, 2025 for SIR, but the court spends years issuing interim orders on forms and hardships, while the program becomes universal. By the time a final judgment arrives, the pathology is permanent. We risk another irreversible fait accompli. The legal root of this issue lies in the Representation of the People Act. The statute's intent is targeted, a special revision for a specific constituency to correct local distortions. However, the Election Commission has implemented this as a statewide and nationwide special intensive revision. What was meant to be a focused tool has been turned into a carte blanche dragnet for mass citizenship verification. This dragnet creates a fundamental inversion of our democratic order. Traditionally, if the state wants to question a specific citizen's rights, the burden of proof is on the state to provide evidence. Under the SIR, the burden is flipped onto the citizen. There is now a mass presumption of non-citizenship, where entire populations must re-establish their most basic rights from scratch. This inversion directly ignores established jurisprudence, specifically the 1995 case Lal Babu Hussain. In that ruling, the Supreme Court held that large-scale removal of names based on general suspicion is invalid. It mandated that notices must be directed at specific individuals and reasons for suspicion must be disclosed. The current SIR process ignores all of these protections, requiring everyone to prove they are voters without individual notice. The tool used to execute this is Form 7. While it sounds like a technicality, it allows any person to object to the inclusion of any other person on the rolls, often anonymously. It has been weaponized to strike people off rolls en masse, bypassing due process. This forces vulnerable citizens to run pillar to post just to prove they exist. These deletions aren't accidents, they are features of this inverted process. We must acknowledge that these administrative tweaks are not neutral. Documentation requirements fall hardest on those at the intersection of caste, poverty, and gender. In a country of vast inequality, a process that accentuates these disparities is more than just inefficient, it is a violation of constitutional equality. It is easy to get distracted by the downstream issues, voter deletions, Form 7 misuse or procedural glitches, but these are just symptoms of the true pathology, a fundamental inversion where citizens are reduced to subjects at the mercy of the state. The cost of this judicial drift is the constitutional order itself. Our framework requires the affirmation of the dignity and participatory rights of every individual. The court must refuse to treat persons as mere cogs in a machine of administrative efficiency. It is time to return to adjudication. It is time to restore the Constitution.